Hi, I'm Jim Love. I am the longtime attorney for the IAOMT, the International Academy of Oral Medicine and Toxicology. And I've done a lot of different things for the Academy over the years. They mostly use me as a writer. That's exactly what happened in 2009 when they asked me to prepare a petition to FDA following the issuance of the FDA's 2009 final rule. The final rule basically said that amalgam fillings are completely safe, that the amount of mercury coming off those fillings is de minimis, certainly a quantity well below the reference dose that was established by EPA back in 1995, I think it was. And so, and they basically prepared a risk assessment in connection with amalgam fillings, and they told us what the numbers were, what the reference dose was, what the daily observed dose was, all the way up to a range of 1 to 10 fillings. And they said that as a result of the risk assessment and the clinical studies that were available, they were going to classify dental amalgam in FDA's Class 2. And we identified somewhere between 20 to 25 mistakes in their analysis. Our petition was at least enough to induce FDA to consider scheduling advisory committee hearings in 2010. I mean, we've never gotten a response to our petition. We're told by FDA very candidly that the matter has been sent to HHS for consideration, and we don't know what HHS is really doing with all this, but recent communications have indicated that they're doing some kind of cost-benefit analysis, and there's no indication of when that analysis might be concluded. In view of the fact that so much time has gone by, speaking today, it's March 2013, no response to a 2009 petition, it became apparent to me that in view of the recent published science, that we should supplement our petition. And it became apparent that in view of the fact that these advisory committee hearings have already been held, that we were obligated to submit a new petition and request leave of the commissioner, who is Margaret Hamburg at this time. She was the commissioner back in 2009 when we sent our petition in, and was also the commissioner at the time that FDA issued its final rule. She tells us that she was not a part of that process. I guess we really have no way to know. The doors are closed at FDA, but she recused herself publicly and said that as a result of her association with Henry Schein, which distributes mercury fillings, that it was not appropriate for her to be a part of the decision-making process. Let's fast forward to March 7, 2013. The regulatory scheme requires that we seek the permission of the sitting commissioner to supplement our petition. It seems appropriate to me that if she was not a part of the decision-making process in 2009, that she probably shouldn't be in 2013. So my expectation is that despite the regulatory scheme directing us to the commissioner, that decision-making will be handed off to somebody else. The petition that I sent to FDA on March the 7th incorporates 26 new papers. But the impetus of this whole exercise was to get the Geyer's papers, Richardson's papers, and Woods' new paper that came out last summer into the administrative record. In my view, everything else is an add-on. We send in this supplemental petition. We have to wait for Commissioner Hamburg to give us leave to send all this paperwork in and make it actually part of the administrative record. Once that occurs, it's my understanding that FDA has an additional 3 months to respond to these additional papers. The regulatory scheme is kind of funny the way it's written, because it says FDA has 3 months, but if they need more time than that, then they can have 6 months. Well, if Margaret Hamburg gives us leave in the relatively near future, my advice to IAOMT would be to delay an ensuing lawsuit another 3 months, give FDA a fair chance to respond to all this, and then file a lawsuit to have a court compel FDA to prepare this response to our 2009 petition as supplemented. Where judicial intervention has been sought, I'm not aware of any case where a court has said that FDA, for whatever reason, is excused from preparing that response. So if things unfold the way I hope they will and the way I expect them to, then I would think that before the end of 2013, a court would require FDA to prepare this response.